on the record calling 21170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this trial, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr. Hurst.
We attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
Buckle up, guys. Today we're going to witness how a courtroom sets the tone. This opening exchange immediately exposes the defendant's refusal to engage with basic discovery and the judge's swift intolerance for gamesmanship. The judge's firm questions and the plaintiff attorney's measured presentation create a crucible where the defendant's strategy starts to unravel, raising the stakes fast. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. By open written discovery in this matter, you have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
In this clip, the judge warns the defendant that unanswered requests for admission will be deemed admitted. The court explains procedural consequences plainly. The defendant's confusion meets legal certainty. As a third-person observer, you can see how ignorance of process is treated as risk. The judge frames the doctrine that silence can equal admission, and the pressure mounts. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
Your Honor,
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She
I'm
cut
going to
me
mute
off.
you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh,
You
my
will speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Here the defendant insists he doesn't understand the debt and asks basic questions. The judge responds with impatience. From a third-person viewpoint, this segment shows a clash between lay misunderstanding and court procedure. One side, demanding clarity, while the other faces a blunt reminder that legal obligations aren't negotiable through rhetoric or disbelief. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
This short but tense exchange has the judge asserting courtroom order after interruptions, then the plaintiff's counsel confirming documentary disclosures. Observing it as an outsider, you notice how decorum and evidence interplay. The judge protects the record, and the plaintiff signals preparedness, tightening the squeeze on the defendant's evasive posture. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
And allow Mr. Hurst to speak. Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't.
The plaintiff's attorney details the account statements and chain of title. Then the judge invites the defendant's response. Watching as a neutral narrator, this sequence highlights the evidentiary backbone of the plaintiff's case, paperwork and chain of custody, and shows the judge balancing giving the defendant voice while signaling that mere protest won't replace proof. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance.
I don't know if they're trying to contract with me or not know what it was, so I send it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences.
Here the judge delivers a pointed lecture about court rules and self-representation. The defendant's sovereign citizen-style objections clash with real-world procedure. As an outsider, you see the court's effort to educate and warn. A stern reminder that personal beliefs don't override procedural obligations, and that choosing to forego counsel carries real consequences. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in
the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you,
they are claiming that this debt belonged to me, but they have to produce all the proof and verify that this debt belongs to me.
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
In this clip, the defendant challenges verification and the judge clarifies the burden of proof. Seen from a third-person stance, it's a pivotal teaching moment. The judge delineates who must prove what and why. The exchange reveals a gap between the defendant's demands for proof and the legal reality that the plaintiff carries the evidentiary load to substantiate the debt. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
All right,
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think
The judge offers one more chance to accept the packet and warns that failure will be fatal to the defense. As an observer, this is the classic judicial mercy and warning sequence. Procedural generosity paired with a clear timeline. The court reframes accommodation as opportunity, and the defendant faces a practical deadline with clear legal consequences. The exchange is not just legal formality. It reveals character, strategy, and the practical cost of theatrical resistance in court.
170598, Midland Credit Management versus Kevin Hurst. Taking time for pretrial, your appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
Yeah, I'm asking
Yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. Then let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have Request for admission number 8. Does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that.
In the climactic stretch, the judge reads the record, noting the defendant's admissions and the absence of a supporting affidavit. Summary disposition is granted for the plaintiff. From a third-party lens, this is the denouement, where paperwork, procedural defaults, and judicial candor converge to end the case decisively. The finality is instructive. Process and proof beat performance every time. If you like the video, please like the video and subscribe to the channel, and we'll see you in the next video.